I didn't get the adrenaline rush drafting a will that I got trying a case. So I was not a card-carrying member of either party. And what I found out was that resulted in neither party trusting me. A good judge will not inject themselves into the case unless they have to. One guy had a T-shirt that says, "You're only guilty if you get caught." Everyone had an excuse, if you will, for speeding. I was going with the flow of traffic, which I developed my response to, Judge, I was going with the flow of traffic is, that's the grown-up version of all the other kids were doing it. Judge, I got caught in the car that was in front of me, draft. And it just drafted me, just sucked me down the highway. And when I responded, she was in tears because a neighbor's dog had jumped out of nowhere and in less than 20 seconds ruined our careful breeding program.
Welcome to another edition of No Holds Barred. I'm Rich Roth, and my guest today, retired attorney and Judge Ed Burnette. Hi, Ed.
Good afternoon, Rich.
Appreciate you coming in. I'm excited to talk with you.
Oh, thanks for having me.
Absolutely. It's funny. I know more and more people who know you now that we've decided to do this. And it's funny. The way this whole thing evolved was us working out at Crosswhite and just getting to know each other a little bit in between while resting, right? After Hunter's working us out a little bit too hard. But resting and getting to know each other. And we just got to talking and, learned about you being a retired judge and figuring, man, you've got a great personality. We have a lot of fun talking and you must have had a ton of great stories. And the more we've kind of talked, there's some good stuff there.
Well, being on the bench for over 18 years and being an attorney for 23 prior to that, you do accumulate some good stories. So,
and I look forward to hearing some of them. And, there's a lot else about you that we'll get to know as well. And I'm excited to do that as well. But just kind of getting things started, you mentioned that you started off as an attorney, went to William and Mary undergrad, William and Mary Law School, right. Great school here in the Commonwealth. When did you decide you wanted to be an attorney?
Pretty much in high school. I was interested in political science and in government, so that was kind of the path that most people took in college to get to law school. And I had always been just kind of enamored with lawyers on TV and the ones that you read about in the news. So that seemed to suit me and something I wanted to pursue.
Now, what type of lawyer were you wanting to be? Because when you talk about seeing attorneys on TV, it's usually in the courtroom and, the big murder trial or whatever. Is that originally what you were thinking?
That's exactly originally what I was thinking. But then after I got through my undergrad at William and Mary, my focus changed quite a bit, and I decided that I really wanted to have a more sedate practice, if you will, an office practice without all the deadlines and the drama. And so I gravitated towards trust and estates, wills and trust and estates in law school, and took the tax courses. My dad was a CPA, and so he told me, remember the two certainties, are death and taxes. So estate planning is a good thing to get into. So that's really was my focus in law school, and I really did not envision myself as a trial lawyer.
So that changed. Ever any regrets about not doing that? And we'll kind of get into the judgeship
Sure.
A little bit later as well, because then obviously an opportunity to see all kinds of different cases. But ever any regrets about, kind of the direction and the path that you took as an attorney?
No, I would feel very, very blessed that the path led me to being a trial lawyer. I never would have been a judge if I was doing wills and trusts. That's not the typical path you want to take if you want to be a judge. So being a litigator for those years really worked out for the best.
It was interesting hearing you tell me kind of as we were kind of talking in advance of sitting down for this conversation about how things evolved, because you originally jumped on board And it used to be Woods Rogers, right? Now it's
Well, it is Woods Rogers now.
Woods,
it used to be Edmonds, Williams, Robertson, Sackett, Baldwin, and Graves.
Wow. That's
then
a
shortened
mouthful.
It was a mouthful. We shortened it to Edmonds and Williams because no one could remember past the first two anyway. But yes, I started with Edmonds Williams, and when I joined the firm in 1978, there were 11 partners and me.
Wow.
I was the only associate. So a classic example of too many chiefs and not enough Indians. But yes, I was the only associate.
And you were telling me that you got into it. You joined the firm to be a will and trust and estate planning attorney, as you kind of envisioned.
Right.
And that quickly changed.
It did. I was under the wing of Edward Graves, one of the senior partners, just an iconic member of the local bar and highly regarded statewide, and was thought my path was going to take me there, but one of the partners who had been the number 2 litigator in the firm decided to change career paths and left the firm, and there was a gap. And of course, they looked around, and at the time, I was being the only associate. They said, "You pick up his practice. You take up his all of his cases." And he was a litigator, and so that's overnight. I became a litigator full time.
And you said that his specialty was really in insurance law.
Insurance defense work, yes. So we represented a number of the insurance companies, State Farm, Allstate, the ones that are on the opposite side of the TV lawyers who were bringing the personal injury suits. I was assigned by the insurance company to represent their insureds when they were sued in those automobile accidents and slip and falls and things like that.
It would seem to me, someone who doesn't know a ton about the law, other than when I was in court for numerous speeding violations, and interestingly enough, I never appeared in front of you. So I was kind of disappointed to hear that. I'm like, that would have been a great story. Remember when? But I guess that never worked out, and maybe that's for the best.
That's for the best.
But things have, I've kind of slowed down a little bit as I've gotten older, which is a good thing. But not knowing a ton about the law, it would seem that if you train, study, and prepare to be a will and estate and trust lawyer, that all of a sudden switching to insurance law, that wouldn't be the easiest thing. A lot of work, a lot of studying, a lot of prep.
Right. Well, I of course have had the basic classes in evidence and things like that. They are required courses, even for if you will, trial lawyers. Mm-hmm. So I'd had certainly courses in evidence and procedure, Virginia procedure, and things of that nature. So I had some background, but back then you didn't get a whole lot of practical experience doing trial work. The most things that were going on back when I was in law school was you would have what's called moot court, where you would argue appellate cases to a panel of judges. But that's totally different from trying a jury trial in front of a jury of lay people typically. So different skill set indeed. So there wasn't a whole lot of training, and it was mostly on the job and do it as you have those cases. So that was really what happened. And I will say that when I first started practicing, it was customary before the days of public defenders for local members of the bar to volunteer to take cases for indigent folks. And so we had a very good tradition of that in Lynchburg, and my firm encouraged me, even though I was going to do the trust and estates, to do that and fill that responsibility. So I was on the court-appointed list for a number of years, so I don't want to give the impression I never got to court before I started. But so I did take some court-appointed cases, mostly in general district court, and no serious felony cases for the most part. But it did give me at least an opportunity to get in court, examine witnesses, make objections, try to make an argument, that type of thing.
Now, that's originally what you wanted to do. And then you decided to change your path to being more behind the scenes. How did you like it, being in front of a judge and being in front of a jury after you kind of decided, I'll just stay in the background and do the wills and trusts and that type of thing? Certainly
a lot more exciting. Certainly a lot more drama, and also a lot more pressure. It was a mixed bag. But I must say, your adrenaline I didn't get the adrenaline rush drafting a will that I got trying a case. So certainly there was an aspect of that made it exciting.
And the insurance side of things, you were defending, and we had this conversation previously to kind of help me understand a little bit more about how it all worked. But you worked for the insurance companies, but defended the insured, which is kind of an interesting dynamic in and of itself.
It is, and it poses certainly potential for conflict because the insurance companies are paying your fee, but your client is the insured, is the individual that's being sued. So those aims of both of those the individual and the insurance company don't always coincide, let's say.
Kind of serving two different masters.
It is, and sometimes you would recommend a course of action that you thought was in the best interest of your client that the insurance company didn't go along with. So then you had to work that out. But at the end of the day, my ethical responsibility and duty was to the individual client, and they always prevailed as far as what I would do. I would do what I thought was best for them, and that sometimes, not often, but sometimes ran afoul of what the insurance company wanted me to do.
Without, and I'm sure you can't get into names and different things like that, but can you give a more specific example of sort of that conflict and that balance and that fine line you had to walk?
Sure, and there's a parallel, I think, somewhat that people might understand with doctors these days and what the insurance companies will pay for. They'll pay for certain procedures, but they won't pay for other procedures. Now, your doctor may be telling you need this or you need this medication. Insurance company says, we're not going to pay for that. Well, in the context of law, it would be in the preparation of a case. I might think I need an expert witness to testify on behalf of the insured, and they're not willing to pay for the expert witness. Or I think I need to take a deposition of several witnesses that I think are relevant to the case, and I would like to get their testimony on the paper, so to speak. And they may not be willing to pay the expenses associated, basically my time and the court reporters for taking those depositions. So then I'm put in the situation of this is what I think needs to be done to properly prepare the case. I'm going to do it whether I get paid for it or not.
So that's basically what it boils down to is, you wind up doing it even if they're not paying for it. So you wind up sacrificing part of your pay, but you don't, for lack of a better term, screw over the client.
Exactly. And it didn't happen often. I don't want to give the impression that was, but I will say toward the end of my practice with private practice before I went on the bench, there seemed to be more and more managing, I would say micromanaging cases by some of the insurance companies and others. And it took away a lot of the discretion that we enjoyed, that the attorneys enjoyed handling those cases. We used to get the files, work them up, try them or settle them, and move on. The next thing we're doing is preparing a budget for the litigation and submitting, reports and all of this type of stuff. That I understand the need from the insurance company standpoint, but it wasn't what we were used to doing as insurance defense attorneys. And
you shared another example with me in terms of maybe somebody's liability limit being low and there being the ability to settle it within that limit, but the insurance company saying, no, we can win, we won't have to pay anything. I mean, another tough spot for you to be in.
Exactly. And those are the cases where I think the lawyer feels the most pressure. The example I gave you was, at the time, that's changed now, but when I was practicing, the amount of insurance company coverage you needed to have on your automobile by law was $25,000. Now, if you're in an accident and seriously injure somebody, that is not going to cover the cost of that liability. So you're exposed. And what that means is the insurance company would pay us $25,000, but then the individual is on the hook personally for any excess, which means they can come after their assets, their home. I mean, it's a real risk. So in those situations where I had an opportunity to settle the case within the policy limits, obviously that's what the insured, the individual wanted. I don't want to take the risk of my personal assets being in jeopardy here. Yes, settle this case. But other times, the insured wasn't at fault in causing the accident. And yes, there may have been a very serious injury with serious consequences to the other person involved who's bringing the suit, but there is a viable defense. There's a viable defense that the insured has, that perhaps the other person was at fault. And in Virginia, we have a law called contributory negligence, that if the other person is at all at fault, they can't recover. So in those cases where the insurance company says, look, we can win this case, we may not have to pay anything, the poor insured's over there saying, yeah, but I'm risking my individual exposure. So those cases, really, that's when the pressure was on the attorney to do the best they could to win the case.
Because again, you're being paid by the insurance company who's saying, don't settle. And your client is the insured who's saying, please settle.
Right.
What do you do?
Right. Well, as a practical matter, what typically happened was there's other insurance now.
Okay.
and it's not the insurance of the insured, but the person bringing the suit, and they have underinsured coverage. And I don't want to bore your listeners with a lot of the legal details, but there was another layer of insurance coverage that could be tapped that was not the insured, the individual defendant, but was actually the plaintiff. The person that's bringing the suit has their own insurance coverage that might kick in. But then you might have that, they might be of the same opinion. Yeah, we don't see the exposure in this case. We're not going to pay this. So the lawyer just has to try the case.
Was there ever a situation where you made the decision that you regretted as far as which way to go? Siding with the insurance company that's paying you or the insured that's your client. I mean, you're between a rock and a hard place. One's saying one thing, the other's saying the other, and you're stuck in the middle having to make that decision.
Right. Well, I was always guided by the principle that my client was my primary responsibility. They're the person I was representing, and I was going to do what they wanted to be done. And so I would take that position. I mean, if the insurance company didn't go along with it, I would still advocate their position. The insurance company could say, well, we're still not going to pay, and I would still have to try the case. But I had at least been an advocate for my client, for them to take a different path. And fortunately, I did not have a situation where there was a significant excess verdict given while I was trying cases, much to my relief.
Yeah, I can imagine that would be a really, really difficult situation to be in.
Absolutely, yes.
Because then, of course, your law firm is sitting there going, everybody's in a tough spot.
Absolutely, yes.
So there are a number of different things I want to talk to you about because having gotten to know you, I know you love to travel. So I want to touch on that. I know you love music. You're in a band. You were in a band a long time ago, and I want to touch on that as well.
Sure.
But you make the transition from being an attorney to a judge. How does that work, and why did you want to do it?
Well, as I mentioned earlier, I practiced for 23 years, and most of that time was in the courtroom, was doing civil litigation primarily, and it took its toll. The stress of being a litigator and trying cases, and I'll have to say that at least in the civil area, there were more civil cases tried back when I was practicing than are actually tried now. It's rare that the civil cases go to trial. Most of them settle now.
Okay. But
back in the day, we tried a lot of cases. I mean, there were sometimes I would try a couple a week. Which is unheard of now. You'd never do that now.
Why the change?
Well, I think mediation has come in, be very fashionable, and at that time it was not the thing to do. It was a sign of weakness, if you will, and kind of criticized in legal circles. And lawyers didn't initially embrace it, but the insurance companies bought into it, and more and more cases ended up going to mediation and being resolved. And I think that it really is fine. I mean, I was actually a mediator as well, and with a mediation group for a number of years before I went on the bench, and it became more accepted. But back in the day of, let's go to trial. That was more the mindset. But I think that mediation really helped get a lot of these cases settled, and a skilled mediator can help both sides see the risks involved, and then they come to a settlement.
So back then, when it wasn't as accepted, was it sort of an ego thing? My attorney's better than yours, and we're going to prove it in court. Was
some of that attitude was certainly there. There certainly was is a certain amount of macho kind of attitude of, all right, go ahead, let's try it. Give it your best shot. Then
we get into mediation, and after a couple of decades of litigating, you decide to try the judge thing. Mm-hmm. Judges are not elected here, as you pointed out to me previously, because I wasn't sure. I mean, some I thought might have been elected, but here they're appointed. And that whole process is an interesting one in and of itself.
It is. It is. We are appointed by the legislature, and depending on what level of court you're in, the terms differ, usually between 6 and 8 years. As a practical matter, the way it works is the legislators who represent the geographic areas that are included in the particular judicial district or circuit are the legislators that decide who the judges are going to be in their district. So Lynchburg, for example, is in the 24th Judicial District Circuit. So we have the city of Lynchburg, Amherst, Bedford, Campbell, and Nelson counties. So any legislature that had a piece of or represented one of those jurisdictions would have a say in who the judges are going to be. Mm-hmm. Now, as a practical matter, the next level is, all right, where is that judge going to sit primarily? Because although that's our circuit, we usually have judges that sit in certain designated courts. So a vacancy for one of the two judgeships in Lynchburg, the senator, state senator, and delegate representing the city of Lynchburg are going to have the greatest say among the senators and delegates that represent the greater circuit in who that next judge is going to be. So that's how it works.
And kind of, I don't want to say bringing it full circle because that's not accurate, but relating it, maybe a better way to put it, to what we're seeing now politically, right? I mean, that's a big factor, right? Because different areas have different, political slants and different Democrats, Republicans, conservatives, liberals, some going further on each way. But those people are appointing judges with similar mindsets. And, and now what we're seeing, and I'd love to get your thoughts on this, but we're seeing, lower court judges overruling a president, and now that's going to the Supreme Court. Can you help me understand how that all works?
Well, it is no question that it has become very political, if you will, and that there's no question that the legislators are going to try to get judges that they believe will be more in tune with their interpretation of the law. And I think we've seen it in Chief Justice Roberts on the U.S. Supreme Court. I think there was an expectation when he was appointed that he would rule a certain way, and I think he has kind of disproved in some respects that notion that just because you are identified as somebody that might be this way, particularly if you have not been a judge before and have written opinions that give a clue to how you view things, I think at the end it's a much better system than having popular elections, which a number of states do. Even North Carolina, you're going to go through election time and have signs in the yards, vote for Ed Burnette, for judge, and to finance those campaigns is what they are. Yeah. Then the opportunity for conflicts of interest and those people that have supported you expecting something down the road, if they end up in court or end up in litigation and want have an expectation that you're going to see. It's just fraught with conflicts of interest that I think we do not have, at least that aspect of it in Virginia.
I think if my memory serves, it may be that way in Maryland as well, because I remember driving through. My son goes to school up there, and I remember vote for Judge Amy, and it wasn't even her last name. It was
Right.
like just Judge Amy, and I'm like, for a position as important as a judge, I mean, and we've got glamour shots, and it really, I mean, it turns into a
popularity
yeah.
contest, and I think that the other part of the selection process that goes on is the local bar associations traditionally would endorse a candidate. And so you would think, and I think for a long time this was the thought, that lawyers in the local bar would know who would make the best judge because they practice with them. They know them. They know them from keeping their word, for being on time, for being educated on the law, and who have the right temperament to be a judge, which is a very important aspect beyond just your knowledge of the law. And the bar associations would get together and endorse a candidate that they would recommend to the General Assembly, to the delegates and senators of the district, as their pick, if you will, for the judgeship. And by tradition, most of those recommendations were taken to heart by the delegates and senators, and they were the people that became judges. Not always, but the vast majority of the time, up through close to the millennium, that was the way you did. So you wanted to get the endorsement of your local bar association. That greatly enhanced your chances of becoming appointed by the General Assembly. But about the time I was interested in going on the bench, that mindset changed, and they had every right to do so. But the members of the General Assembly made it clear and wanted to send a message to the local bar that they would pick the judges. That you could submit your names, your recommendations, but we're going to make the appointment. We are going to make the appointment, not you.
And I want to get into that in just a second, but I want to follow up on the point we were just talking about a second or two ago with what's going on now kind of nationally with Trump. And I believe the Supreme Court recently ruled that, lower courts don't have the authority to overrule the president, because I think we saw that with the guy who was deemed the Maryland man, right? And Trump shipped him off, but some local judge overruled it, and then all of a sudden it blows up. How did that all evolve, and how can a local or a lower court judge, how does that work?
Well, that'd be a great question to ask Judge Norman Moon, and I would love for Judge Moon to give his thoughts on that, because the courts you're referring to are federal courts,
Okay.
the federal district courts, and that's where a lot of these cases, if you will, that are making the headlines now, particularly involving the executive orders by the president, are being litigated, and that is a totally different court system from the state court system. There are some state courts that are involved in those kind of cases, but the vast majority of the cases you're talking about are federal courts dealing on federal issues, constitutional issues, and I'll defer that to my friend and I admire very much Norman Moon, who would be much better suited to answer that question.
Well deflected. Well deflected. Okay, so getting back to you, you told me that it took you a couple tries to become a judge because a lot of the state senators and delegates weren't quite sure about your politics. Is that right?
Exactly. I naively thought that because I was basically an independent, I voted Republican and Democrat, depending on the person that was running.
Go figure.
And
it's about the individual,
it was
not
about the
party.
individual, exactly. And so I was not a card-carrying member of either party. And what I found out was that resulted in neither party trusting me or knowing me, and so I really didn't have any support from either party, and at that point, so and they were skeptical because I didn't fit nicely into either one of their ranks. So that I thought that being an independent would be that's the kind of person you would, with that background, you'd want on the bench. But I quickly found out that that was not the case.
It's interesting because the law's the law, right? And you would think it's pretty cut and dry. But there are such wild interpretations, like by wild I mean wild differences in the interpretations of the law. It's hard to imagine that it can be interpreted so differently.
Well, it is, and one of the things that is the most challenging for judges is to have a case of first impression, if you will, which means it's the first one of its kind in your jurisdiction. And a lot of times there are either statutes or case law that have addressed the issue, and you just have to find them. And that's what we have law clerks for. They can do some research for us and give us the statute or the case that is on point. And if we don't have one in Virginia, maybe somewhere in the 50 states, another court has dealt with it. So there should be some type of authority somewhere for that. But occasionally you do get cases of first impression where you have to make the call, and that quite frankly, that's the most intellectually challenging part of being a judge, is when you have to do just that, and you have to go through the reasoning process. You have to look at what law is there, what you think is ultimately the right thing to do, and when you're in those type of uncharted waters, and make the best call you can based on the authority that you can gather.
So you finally get in. What were you feeling then? Was it relief? Was it excitement? What were your thoughts?
I had mixed feelings. I was going to miss being with my law partners and practicing law and being available to help my friends that needed me from time to time in town and serve that role. But I, quite frankly, at that part of my practice, the last about 5 or 6 years of my practice, I was primarily representing lawyers who were sued for legal malpractice. And having lawyers as your client became very, very challenging and very draining. And so I had gotten to the point where that was about all I felt like I could take. So I really was relieved to not have to have that pressure on me anymore. But what I found was, of course, there was a new type of pressure in getting the decision right. What's the right decision? So I traded one set of stress, if you will, for another.
So all right, so let's back up a little bit, because you were defending other lawyers,
right,
in malpractice, and I think there's a saying about doctors, maybe it's attorneys, maybe it's both, but an attorney who has himself for a client is
a fool.
Right. I butchered that, but you get the point.
I get it.
I mean, is that...
Well, it's just, you can imagine, and my law partner Henry Sackett had been a long time defender of doctors that got sued for medical malpractice, and that was really not all that uncommon back then. But suing lawyers was something rather new, if you will. That they weren't as susceptible to lawsuits initially as they are now, and so it was kind of a new thing, and you can imagine the lawyers felt a personal stake in the case. Their integrity in one respect and their competence was being questioned publicly, and so much like doctors that are sued for med mal, there's a lot on the line. And I don't want to make it sound like there are more important cases than other civil cases, but I think you understand what I'm saying when you have a person whose livelihood is at stake in a case. In many respects, there's an added expectation that you better win this case.
Doctors, though, don't really know the law. Other attorneys do know the law.
They do.
And I mean, a lot of second guessing, a lot of, hey, you should do this, do that. I know better than you.
Absolutely. And there's some stronger than others. Some assert their opinions, if you will, much more aggressively sometimes than others. But at the end of the day, I would typically have a conversation with the lawyer client at the beginning of the representation. And just so let's just have some understandings about what's going to go on here and how this is going to go. And it's the same type of conversation you would have with a client, but a little bit different, talking lawyer to lawyer.
Can you think of an example? And you don't have to use names. We'd love it if you do, but you don't have to use names. Of a situation where that conversation didn't go very well? Well,
it wasn't that the conversation didn't go well. It was just that the lawyer listened and then proceeded to tell me when he didn't quite agree with my evaluation or my course of action or my failure to do something. I made a conscious decision not to do something that he wanted done. So that's just the way it played out. And as I said, over a period of time, that got to be a very, very challenging way to make a living. And that's what prompted me to take the opportunity when a judicial vacancy came about. Say, I still want to be in the courtroom. I still love the drama of the courtroom, but I don't want to be in the lawyer spot.
So now you're no longer an attorney, or maybe you are. You're always an attorney, I guess, but you're a judge. What are some of the biggest differences being a judge versus being an attorney?
You have to listen a lot, not talk. You have to listen. And when you're an advocate for your client and you're trying a case, you're doing a lot of talking, whether it's objecting or examining a witness or making a motion. You're talking a lot. A judge has to listen. And a good judge will not inject themselves into the case unless they have to. It's like an umpire representing a boxing match. Yeah, a good referee stays out of the way, lets the two sides go at it, and that's really analogous to what a good judge would be. You have to step in when you need to, but otherwise let them play by the rules and try the case. So that's the main. One of the main things, and then so patience is also what you have to have. In addition to listening, you have to be patient with people, and sometimes that means patient with people that are representing themselves, like I had for a long time in General District Court, where they didn't know the legal process, they didn't know exactly what they had to prove or whatever, and just be patient and hear those cases, and also at times be patient with lawyers when they were off point or didn't have authority for their position and were trying to get you to agree to something that they didn't have any basis in law to argue, and you'd have to be patient and listen to them and let them make their argument and then rule.
Okay, so now you're a judge and you're talking about patience and listening and being in general district court, and there's general district court locally here on the local level, right, and then there's the circuit court.
Correct.
What's the difference? Well,
the big difference is the general district court's kind of the people's court. They're the kind of cases you see on TV, with their traffic cases, misdemeanor cases, their civil cases up to a lower jurisdictional limit. So they're the small claims, although they're not so small anymore. When I left the court, you could come up to $15,000. They probably increased it since then, but so they're not as small as they used to be. But they're usually people don't have lawyers; they represent themselves, and so you have everything from an expired inspection sticker to a DUI or a reckless driving or trespassing, assault and battery, those types of cases. No juries. Circuit court, that's where most of the cases you read about in the newspaper are. They're the felony cases, the serious robberies, murders. Criminal cases are going to be tried. The civil cases that are with more monetary value at stake are tried. Divorces, adoptions, things of that nature are tried.
But in general district court, and you said most of the time people represent themselves. There
Yes.
aren't a lot of attorneys, misdemeanors, different things along those lines. But people could still wind up in jail.
Absolutely. Absolutely. And in the criminal cases, as if it wasn't just a traffic offense, it didn't have any type of jail time associated with it. The most that could happen would be a fine or your license being suspended, something like that. But in situations where you did have a criminal case, a criminal charge, typically those people would be represented by an attorney. But some waived their right or gave up their right to be represented by an attorney and represented themselves. And then, as you mentioned earlier, that usually didn't turn out too well.
Did you ever? I mean, did you ever get in a situation where you sat there and you just looked at somebody and go, "Would you please get an attorney?"
Yeah. Well, it's funny. Some people would come to court and represent themselves, and they didn't do themselves any favors. One guy had a T-shirt that says, "You're only guilty if you get caught," which I don't recommend wearing to court.
That's not the way to go.
Not the way to go. Not the way. Another guy had a bad to the bone belt buckle on. So probably not a good idea to make that first impression with that. But it was just amazing. Sometimes people just wanted to. They thought they could do it, and that's their right.
You told me that you never really had any of the big scandalous cases that really grabbed the media's attention and everybody's attention. Would you have liked to have those?
I would have certainly accepted them as part of my job, but quite frankly, it was somewhat of a relief not to have. I never had a capital murder case. My colleague John Cook down in Campbell County is probably in double figures now with the number of capital cases he's had. I never had a capital murder case where the death penalty was on the table. So it's in some ways it was a relief not to have that. But I did have some that obviously the media disagreed with my decision, and that's part of the job. But I didn't have the real super high profile cases that people are going to remember or recognize.
And you're glad you didn't.
I am. I don't regret not having a case that would have defined, if you will, my judgeship.
Too much pressure?
Well, in some respects, the pressure would certainly be one aspect of it, but that's what we do. I mean, that's. I would, as I said, I would have accepted the responsibility had it been given to me. In hindsight, and not having to go through that and having that pressure, I can't say that I would have welcomed the opportunity, if you will. I would have taken the case, obviously, and tried it, but I'd be disingenuous if I said a little bit of relief went with not having to decide whether somebody lived or died.
You describe general district court as sort of the people's court. So I can imagine, I can only imagine all the different type of stuff you saw. You pointed out a couple cases of people showing up with belt buckles or T-shirts or whatever, but I mean, I bet you've got a million stories.
I've got a couple I thought I'd share. These are the PG cases that I can share online on the air with you. A lot of times,
on the video you can do. Well, you can go R.
Mostly it's just the word. A lot of times, just the words people used. Like in the speeding case, the person said, "Judge, my speed thermometer wasn't working," and that other car hit me right in my right front quarter pounder. So a lot of times it was just a misspoken word. I had a case involving a man was charged with having his dog running at large. Right. And he came in. He says, "Judge, my dog's just a puppy. Can't be that large, right?" It's just amazing. Some of the other fun cases. There was an automobile accident where a Mr. Wren ran into Mr. Sparrow in front of the Oriole Motel in Madison Heights. True story. I mean, what are the chances of that? I mean, it's just just amazing. Another great everyone had an excuse, if you will, for speeding. I was going with the flow of traffic, which I developed my response to, Judge, I was going with the flow of traffic is, that's the grown-up version of all the other kids were doing it. But they're also.
Well, I'm going to jump in because that's one of my biggest pet peeves driving, and I think I kind of made it pretty obvious earlier that I had some speeding issues when I was younger. But even now, it's like, can't you just keep up with the person in front of you? Right. That's all I want. Is just keep up with the person in front of you. They're probably not going that fast. Why can't you do that? But that's not a great excuse.
Not a great excuse. But the other defense that I heard is what I call the NASCAR defense.
Okay.
The NASCAR defense is, Judge, I got caught in the car that went in front of me, draft. And it just drafted me, just sucked me down the highway. So I thought that was original defense there with this, but it's just amazing. And then I had a DUI case, driving under the influence case, where the person was testifying, and of course part of the stop involves taking field sobriety tests. So when the witness was telling me about those tests, he said, well, the trooper gave me those sorority tests. I said, well, I think I know what you're talking about. And other times, just we would get letters, and I brought a couple that I thought you might. And as I said, these are actual letters sent to me as the judge of court.
Okay.
And these, I'm not editing them; I'm reading them as they were written. So I think your listeners would enjoy a couple of these. This was one over in Amherst.
And these are so good you saved them.
I saved them. You've seen my file. I've saved them just.
I can imagine opening the mail going, this one gets saved.
This gets in the memorable cases file. Dear Judge Burnette, I'd planned on appearing in court this date at 9 a.m. to explain my traffic ticket. However, we have a yellow lab that we have bred to a very fine champion lab by artificial insemination. While I was dressing for the courtroom appearance this a.m., my wife had Sweet Annie, our dog, out for her morning relief. My wife was pounding on our side door, and when I responded, she was in tears because a neighbor's dog had jumped out of nowhere and in less than 20 seconds ruined our careful breeding program.
Is that doggy canine sexual assault? Is that what we're talking about?
Now, although this fine takes 14% of my Social Security check, I would pay it if not for the points one of your clerks explained is associated with the ticketed violation. If you could pull my driving record in Maryland, I'm certain it is clean for many, many years. I do look behind when I back up and consider myself a most careful and knowledgeable driver for my age. Sorry to go on, and I appreciate your review, and if another date could be established, I'd much appreciate it. P.S. By the way, our vet thinks that since we bred our dog about 6 days before the other dog's mating, and since there are side effects sometimes with the abortive shot, we're both gambling on allowing the pregnancy to go forward and either have the most beautiful yellow lab or the most beautiful Heinz 57 variety. Wouldn't want you wondering. Sincerely yours. Can't make it up.
No.
Can't make that up. And here's another one I thought might be enjoyable. Just from once again, this is addressed to me as the Honorable Judge of Amherst County. I am a student at Brevard College in Transylvania County, North Carolina. On Friday, August 10th of this year, I was faced with charges of reckless driving. The officer who indicted me on this infringement did so based on his surmise that I was driving 84 miles per hour in a 70 mile per hour precinct. I discern that I am to report to court on Thursday, October 11th. However, my ability to be in attendance is incapacitated. My vindication for this is my midterm exams, which are also scheduled for tomorrow. I'm completely penitent for this, and I hope you give warrant of my obligation. Furthermore, I wish to plead guilty, omitting the reckless driving, My predilection is to plead guilty for a non-moving violation. I beseech you to give consent of my preposition. I am appreciative of you for taking the time to read my letter and would like to tell you of my gratitude.
What college was that again?
Respectfully.
Brevard, you said?
What can I say?
Note to self. Don't let your kids go to Brevard.
One other one I'll just share is sometimes you have to be careful what you ask.
Okay.
And it was part of the judge's responsibility in appointing counsel for indigent people. We have to ask them certain questions to see if they qualify, if they are indigent. And one of the things we ask them is how many people live in their household. And so I asked this particular individual, I said, well, how many people live in your household, including yourself? And so his response was, well, 6. Me, 4 children, and yourself. Can't make it up.
Oh, boy. So you've kind of seen a little bit of everything in General District Court.
I have. And that's why those shows are so popular. I mean, they can sit down really literally in any general district court in the Commonwealth or the country for that matter, and you can see these things play out daily.
What advice would you give people who are going to, say, general district court, something not super serious, speeding ticket, maybe even a reckless driving or something like that, where that's 20 miles over the speed limit or more, I've been told. But what advice? I mean, you're going in. Should you have an attorney? At what point should you? At what point, maybe are you okay going in your own? But, what can you do to really help yourself? Because you said earlier that in most of these cases, people don't have attorneys. They don't really know the law. And I would imagine that you're just sitting there trying to figure out, hey, is this a good person? Is this a good kid? Did they just screw up? Do I want to give them a break? Right? I mean, you have a lot of latitude there, I would imagine.
There's no question about that. And there's a lot more leeway in general district court than there is in circuit court to kind of make things come out right sometimes. And so my advice would be to seek advice of an attorney first. I think that is still recommended, whether it's your charge or your children have a charge or whatever. I think that consulting an attorney is the way to go. And then you want to be on time. You want to be polite, and you
want to leave you're only guilty if you don't get caught.
Yeah, not a good idea to wear that T-shirt or wear the bad to the bone belt. But I think the attorney knows what to say and what arguments to make, and more importantly, the attorney knows what not to say. Because there's some things that just rub certain judges the wrong way. Some judges are going to be more lenient in some types of cases than others, and the lawyers know which judges have those kind of leanings, let's just say, and they'll know whether the defense that you intend to present is going to be something that judge would really entertain seriously. And sometimes, quite frankly, there's some judge shopping. Sometimes the lawyers will know if Judge so-and-so is on the bench that particular day that this case is set, they may ask for another court date to a date that another judge may set that may not be of the same idea with that particular case. So I'm not saying that's just a fact of life, but that's what attorneys do. And the layperson wouldn't know the book on a particular judge and what defenses are going to work and what defenses are not going to work, or what things he or she would entertain as an argument or not. But the lawyers know how to do what is needed to get the best outcome. And sometimes it's having a different judge.
Are you glad the way things worked out for you?
I am. I consider myself very fortunate, very blessed to have had my years here in my hometown as an attorney, practicing with wonderful people, wonderful partners in my firm, role models for me, and then on the bench to have joined a very good group of people. My colleagues on the bench was a wonderful, wonderful, wonderful way to make a living.
So no regrets that the music career didn't work out?
Well, I think my father gave me good advice there. Back in high school, my high school rock and roll band cut a record that was a regional hit, the greater Lynchburg area, and there were at times where we thought we were going to hit the big time and make it in the business in the rock and roll world. But I'm glad that my father said this is a better path and get to Williamsburg. So I don't regret that at all. What I do regret is not keeping up with my music during my college and law school and law practice and judgeship, and not literally putting the trumpet in the closet for 50 years. It has been a joy to have dusted that off and playing music with some of my old friends, including one of the members of that band in high school.
Now, the internet's a wonderful thing.
Yes.
Lots of stuff lives in perpetuity there. Ashley? This is you guys.
This is us. This is the greater experience. The song is Don't Forget to Remember.
What year?
1970.
Is that you on vocals?
That's not me on vocals. I'm doing some of the backup vocals, the Love You So, and trumpet.
So this didn't ultimately pan out as a career.
Not as a career.
And you mentioned that you put the trumpet away.
I did.
And then you dusted it off because you said you got together with some old friends and you're playing in a band now and some beach music. Tell us a little bit about what you're doing now. I know Dr. Davis is in the band.
Yeah.
I don't know everyone in the band.
Yeah, Mike Davis is the leader of the band, a retired dentist now, and Nat Christian on keyboards, and my friend Russ Hovdahl on bass, and Reggie Hunt on drums, and Kenny Mayo on saxophone, and well, we call ourselves Second Wind Band. All of us are 70 plus in years and love music, and we all grew up in the 60s with a lot of the good Motown rhythm and blues music and the Carolina beach music. Mm-hmm. It's still popular, and so that's kind of our niche. That's the music we play because it's the music we grew up with and love it, and fortunately there are enough people in the area that love it too that we get to perform for them.
How many gigs do you have? A week, a month, what?
We usually have 2 a month,
okay.
Which is what we shoot for, and we practice every Monday night or once a week usually, and so we try to get some new material in our song list. So it's not all in the 60s and the ancient history. We play Uptown Funk by Bruno Mars and some other September by Earth, Wind and Fire, some more recent tunes. But most of our mainstay is back in the 60s and the good old tunes.
How much fun is that?
It is great. It is wonderful. I feel like I'm back in high school, just young again. Just it brings back so many great memories of just that time, that period in my life. It was just it's just like being back in the 60s again, in the 70s.
And you talked about the fact that after 50 years you dusted off your trumpet. You wished it hadn't been so long, though.
I do. I really regret that I did not, even though I may not have played in a band, that I didn't in some way keep my music up and do something in that time. It was a big part of my life up until college, and I didn't quite appreciate just how much of a part of my life it was till I took it up again and realized what I was missing, what I'd missed.
And music runs in your family as well.
It does. My mother was a very gifted pianist. She could play by ear. If she heard a song one time, she would know it and could play it just beautifully on the piano. And she was, and she encouraged me to listen to the contemporary music and classical music and music from big band music from the 40s too. But I credit her with my love for instilling the love of music in me, and it was a wonderful gift.
And not just your mom, but your nephews.
Well, you know them. You know them.
It's a small world because we were talking, I believe, earlier this week. And you told me that that your nephews, along with their dad, your brother-in-law,
That's right. Yes.
had participated in, and we had a ton of fun with this on the Sports Line years ago. You know, it started out as a stupid little contest, and it really grew into something that was a lot of fun. But before the Virginia Tech game, we would have a song parody contest.
Right.
And, you know, you mentioned, you know, my nephews were in that, and I knew right away.
Yeah.
You know who they were, the Conley boys.
The Conley
they called
boys,
themselves.
absolutely, and their dad, Steve, my brother-in-law, and my sister Larkin, and once again, I've encouraged them in music, and I also take credit to my mom being an influence as well. But they did. They share the love of the music, and they're very creative and sharp, and. Yes, they've grown up with music in their lives, and I'm delighted.
You know, it's so funny because I remembered it right off the bat, and I remember that one of our contestants was very frustrated that they were able to join because they felt like there was a huge advantage to having a couple of young kids to really sway the judges, so to speak. But I don't know if you ever heard what they did. We've got it.
Well, I heard it at the time, but I'll be honest, I can't remember the parody myself.
I needed fans, lots of fans in our new stadium. Should have fenced them in. I needed fans, lots of fans, and some help from up above. Should have fenced them in. I didn't win 7 games, so I packed up my baggage. Instead of eating steak, I've been living on cabbage. I miss the University of the very average. Should have fenced them in.
And then they really get going.
In constant sorrow at every game. We are the fans of constant sorrow.
And this,
we cry at
one of the songs from "Oh Brother, Where Art Thou?" And I think I was telling you, someone was talking about this and playing this the other night, the real song. And I'm like, man, that sounds familiar. And it was at a 4th of July party just a week or so ago. I'm like, I know. And they were, oh, brother. And I'm like, oh, wait, I know that. And then all of a sudden, you're telling me, and man, small world.
It is a small world. It is a small world. Absolutely.
So music, and I know you also love to travel.
I do. I'm
just back from Turks and Caicos and ready to go again.
Ready to go again. I took up scuba diving over 25 years ago, and that's I have at least one scuba trip a year, that usually to the Caribbean, that I enjoy. So I'm headed to Roatan, Honduras, which is going to be another great trip. And I have a group that I meet every year down there that we've gotten to know each other. And so that's the fellowship that goes along with that. Topside, in addition to what we see under the water, is fabulous. So really, really enjoy that.
And then later on in the year, Europe?
I'm very, very fortunate. I have a fraternity brother and his wife, and his wife has a travel agency in Richmond, and she has put together some wonderful trips to Scotland, Croatia, and this year I'm headed to London, Paris, and Switzerland.
Wow!
So, it's just so wonderful because they take care of all the details. I just give them my credit card and ask them, tell me when and where, and I'll be there. So, and traveling with them is a joy. They're great people. So. I've seen parts of the world that I've never seen before, thanks to them.
Do you go to a lot of different places because you want to see different places, or is there a place that you kind of gravitate towards more often than not?
Well, obviously with scuba diving, you want to go where the diving is going to be best. And unfortunately, there are fewer and fewer of those places. Bonaire and the Caymans used to be the places you would go. The reefs in those places are not what they were when I started scuba diving in 1997. And all the reefs are in distress. And so it's really sad in some respects to see the condition that under the ocean now, that it's there, and and remember what it used to look like. So there are fewer and fewer places now that you can go where you can see healthy reefs and a lot of fish. So there are fewer and fewer choices, particularly close by. Indonesia used to have the reputation of being unspoiled. Now they're even in the midst of bleaching and corals dying and having issues. So it's made me much more aware of the environment, particularly as it pertains to the ocean, and we need to take better care of it.
Judge Ed Burnette, thank you for joining me. This was a lot of fun.
I enjoyed it here. Thank you so much, Rich.
Appreciate you dropping by. No holds barred. We'll do it again.
My pleasure.